Thank you, Madam Speaker, and I yield myself such time as I may consume.
And the gentlelady is recognized.
While 1 in 6 women will experience sexual assault in her lifetime, as many as 1 in 3 women leaving military service report that they have experienced some form of military sexual trauma. By the Pentagon's own estimate, as few as 13.5% sexual assaults are reported. Additionally, while 40% of sexual assault allegations in the civilian world are prosecuted, this number is a staggeringly low 8% in the military. The military has been slow to take the appropriate actions necessary to protect victims of sexual assault. For example, rape victims still do not yet have the right to a unit or duty location transfer following an assault. This means victims of sexual assault are often forced to live and work alongside their perpetrator, facing repeated stress and trauma due to the constant contact they may have with an assailant that is part of their unit. As unbelievable as it sounds, this is exactly what happened to Marine Lance Corporal Maria Lauterbach, who accused her assailant of rape and then spent the next 8 months exposed to the accused rapist, who later murdered her and buried her with the body of her unborn son in his backyard. Although these events happened in 2007, the Department of Defense has not adopted provisions that would allow victims to escape constant contact with their assailant. We ask men and women who serve in the military to put their lives on the line for our country, and they shouldn't fear harm from their fellow service members. We simply must do more to protect them. In May, this House passed H.R. 1540, which included strong bipartisan provisions that would allow victims of sexual assault the right to transfer units, the right to counsel, the right to privileged communications between a victim and a victim advocate, and the right to get records of their sexual assault so they can be eligible for veterans' benefits. These provisions came from a bipartisan bill that I introduced with Mr. Turner of Ohio. Our language stipulates confidential communications cannot be used by the defense attorney against a victim during court proceedings, and they remain truly confidential. These provisions will encourage more victims to come forward and get the help they need to heal, and will encourage more victims to participate in the legal process of prosecuting perpetrators of sexual assault, both of which are critical to maintaining readiness and unit cohesion in the military. These provisions also establish full-time sexual assault response coordinators and victim advocates, ensure they are well trained for the job and able to properly serve victims of sexual assault. The 2009 Defense Task Force report on sexual assault in the military services found that current victim advocates and sexual assault response coordinators are unprepared for the duties of the position. In the words of a current unit victim advocate, quote, "I would truly be unprepared if a sexual assault were to occur and my services were needed. It is my opinion that active duty victim advocates are not prepared to deal with sexual assaults and could potentially deter individuals from coming forward. Having full-time SARCs at VAs with extensive training and certification will ensure that they are truly a valuable resource to their unit and to victims who come forward." This language also improves the retention of sexual assault records and guarantees that victims of sexual assault will have lifetime access to these records for a variety of purposes, such as being considered for veterans' benefits and given priority consideration for counseling at Veterans Affairs. Currently, survivors of sexual assault have to jump through multiple bureaucratic hurdles to prove that their symptoms are connected to an incident of sexual assault in the military in order to be prioritized for mental health counseling or be eligible for benefits. Service members find it difficult to obtain documentation proving their sexual assault once they have left the services because many of these documents are destroyed at DoD after only a few years. This language ensures that the documents are maintained. This language also requires DoD to prepare a record of all court proceedings in which a charge of sexual assault is adjudicated and provide a copy to the victim. Because victims of sexual assault serve as a witness rather than an active participant in trials where their case is litigated, they often do not understand the outcome of their case. These records are prepared where convictions result, but when charges are dismissed or when a perpetrator is found innocent, the victim has no reliable way to understand what happened and why his or her case was dismissed. Making sure victims understand the outcome of their case is important to providing closure for victims and making sure they are an active, respected participant in the legal process. It will help to alleviate much of the mistrust that service members and victims of sexual assault in the military harbor when it comes to how a sexual assault case will be handled if they make a report. Similar provisions were included in the Senate's version of the defense authorization, but these provisions do not clearly spell out a victim's right to counsel and do not provide for a comprehensive education and training program. Yesterday, a bipartisan group of 47 members, led by Mrs. Slaughter and Mr. Turner, sent a letter to the chairman and ranking member of both the House and Armed Services Committee in support of the House's language. This motion simply instructs our conferees to insist on the House language that will protect our servicewomen. I urge my colleagues on both sides of the aisle to support the motion to instruct conferees. With that, Madam Speaker, I reserve the balance of my time.
The gentlelady reserves her time. The gentleman from California.